If you don't believe that a patient, an injured patient, should ever sue their doctor or a hospital, do you think that that would disqualify you from a medical malpractice lawsuit where you are being selected as a juror? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, in all likelihood, yes, that will disqualify you as a juror. Why is that? Because it already establishes that you are biased in favor of one side without having heard any evidence, without having heard any testimony. You're already coming into court with a preconceived idea that an injured patient should never bring a lawsuit against their own doctor or hospital staff. And what does that mean? It means now you can't be fair because you are already starting ahead of the game without having heard any testimony or any evidence. So the moment you are brought into a room and you learn that this involves a medical malpractice case, the attorneys will be asking a series of questions about anything in your history that might prevent you from going ahead and being fair and impartial in this particular case. The moment you say, no, I don't think anybody should ever sue their doctor or the hospital that they were in, guess what? In all likelihood, that is automatically going to disqualify you from being a juror in this medical malpractice case. Now, it's different if you say, hey, listen, I've had lots of experiences, some good, some bad, yet I can still be open-minded and I can still be fair and impartial. Now, that allows you the opportunity to keep an open mind, to recognize that a doctor may have been negligent, he may have been careless at a particular day, at a particular time, and on the other hand, it may also give you the opportunity to realize that the doctor was not careless. By letting us know that you don't believe under any circumstance an injured patient should ever sue her doctor, guess what? That is automatically, in my mind, going to disqualify you from being a juror in this case. So in all likelihood, I will not have to use one of the critical challenges that I have, known as a peremptory challenge, where I'd have to excuse you without having to give any reason whatsoever. Instead, my opponent is likely going to recognize that this juror does not belong on this case because it's so lopsided that she's going ahead and already prejudging what's going on. So why do I share this quick information with you? I share it with you just to give you an insight of what goes on during jury selection, during these medical malpractice cases here in New York. You know, I do recognize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and are thinking of doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.